This conference will now be recorded.
And the reason that's important is just so you know that if you do have any questions that germane to your particular situation, know that this is being recorded. And it's probably more appropriate if it's sensitive to maybe talk to us offline. So I will ask that we, for this type of format, we keep questions to the end. So we will have probably ample time, at least 15 minutes or so, to answer any questions you have. You can certainly do that by unmuting yourself or by putting that in the chat box if you prefer, whichever works. And we'll be happy to answer any questions we have. So before we get started, I need to give you the disclosure. I've already introduced you to Frank. Here's our lovely team. That's maybe you've met us all, maybe you haven't. Frank is another certified financial planner with a lot of experience behind him. So he's going to be our main speaker, but I'll be here as well to answer any questions and to chime in and also be the timekeeper so we don't go too long tonight. Our disclosure is obviously we're not attorneys, we're not accountants, so anything that we discuss tonight is really not designed to be tax, legal, or accounting advice. So we always have to make sure that you're aware of that. It's always ironic because everything that we do as financial planner kind of touches those areas, but we have to give you that caveat, and we will defer you to your attorney or accountant depending on the question. So without further ado, I think we'll get started. Let me just check the chat box. Everybody can hear me okay? Tom, yes, we're recording. I think we're good. So I think from there we'll get started, and I will turn this over to Frank.
Okay, thank you, Todd. A lot of people hear the term estate planning, and it's got a certain element of mystery to it or confusion. For others, the fact that it entails considering your own demise can be a little bit of a challenge. A lot of people, there tends to be a real emphasis on procrastination when it comes to estate planning. But hopefully today we'll point out some of the elements of it, and with a greater understanding, I think maybe everyone will feel a little bit better about the idea of planning. If anything, those that live on past our lives will appreciate it considerably if they don't have messes to clean up. And that's probably a simple way to kind of emphasize why, if you really love your heirs, do some estate planning. So anyhow, as you can see, says that estate basically is everything you own. It's the rights, titles, and interests that a person has in property. So that could include real estate. That could include financial assets. It can include digital assets. As technology becomes a greater part of our life, the value of digital assets needs to be considered as well. And estate planning is basically just a process of planning for your accumulation process, your conservation, and distribution of the estate. It seeks to accomplish both tax and non-tax objectives. A lot of people think that estate planning is only for the wealthy, and it really isn't, because there's so much involved that, as I said, your heirs will appreciate tremendously if it's done in advance. It's also known as wealth planning, and again, the proper planning keeps things together. And the places where money gets siphoned off, if you will, are unnecessary court costs and legal fees. It could be taxes. Again, part of the planning element is to minimize the effect of those, or control the effect of those taxes. But as more than anything else, it's making sure that things are in order when someone else has to handle your affairs. This one.
Let's see. There we go.
Okay, and this is a common retort about estate planning. People feel it's only for the wealthy. A lot of young people will make the comment, "Well, I'm not going to worry about that till I'm older." Well, as hopefully we'll point out some reasons why estate planning for even people in their 20s can make a lot of sense. And so we're going to again emphasize that it's not just wealth and tax planning, but it's also preparing for other eventualities.
Yeah, I was just going to say right here that I know there are some younger folks on the call For those of you who already have your estate planning kind of accomplished and finished, think about your children and grandchildren. So that's part of why we're doing this too, so that we're offering help for your entire family. So you might be okay, but you know, if you're passing assets and property on to your children, they may not be okay, and that in turn is going to go against what you wish. So just want to bring that up.
Okay, so as this slide illustrates, there's several goals and several objectives. You'd like to keep more of your hard-earned money. As we said, there's places that money will be siphoned off. Some of it is unavoidable, but in many cases, proper planning can circumvent that drain. So a greater percentage of your hard-earned money goes to those you want it to go to. Protecting your family. As Todd mentioned, the younger people oftentimes think that estate planning is only for the elderly and the wealthy. Well, one of the things you do with a will is you name guardians for your minor children. And in lieu of not doing that, the state decides those type of situations. So a very important element, even for young families, is the possibility that the parents could be gone, and it's just a decision of who's going to take care of the minor children. And I think most of us will want to dictate that ourselves. It also helps you control your assets. We'll talk a little bit about trust later, which can be very powerful tools to control things. And also is basically being a good steward of your own property, either real estate or financial. And most importantly, for you and your family, there is a certain element of peace of mind knowing that preparations have been made as opposed to leaving things up to chance. Our goal with all of our clients is that none of you fall into this group. Unfortunately, about 70% of Americans, I've seen this number vary, it's in the 60s and 70s, a relatively high percentage of Americans will procrastinate. Again, it is psychologically, it's difficult to plan for your own demise, but I think most of us would agree that it's probably a responsible thing to do. And there's also a tendency to just put it off because it takes some time, it takes some effort, but in those cases, it can be very late. And if, as the bottom line says, if you don't have a will, the state has one for you. And most of us would not always want to, trust the government to do what we think might be in our best interest. So let's look at some of the planning options as they relate to keeping your family's wealth in your family and in the ways that it's most efficient. And again, I can't emphasize enough that it's much more than just taxes. It's the probate process or trying to avoid it, among other things. So it's try to think very broadly when you think about estate planning.
Yeah, I was just going to add that under current law, most people aren't going to have an estate tax issue at all. So a lot of what we're talking about is really about protecting your family and really, disposition of your assets really than it is about taxation. That may change in the near future, but for now, taxation is really minor for most people.
Okay, in the sense of needing to process the passing of your estate, your property to the next generation or the generation after that, if it's grandchildren, there are some events that take place in that process. And in many cases, you want to try to, I don't necessarily always avoid, but avoid or minimize. One of those is the probate process. We'll talk in more detail about probate. And, you'll hear in some cases horror stories about probates. Todd and I read a lot of financial literature, and it's kind of interesting to see how screwed up things get for people like Prince or Michael Jackson or other famous athletes or public figures, because they didn't do a very good job or didn't do any estate planning. But probate is something that varies by state, but it's something that just about across the board you want to try to minimize the involvement. One of the drawbacks of a probate process is it's a public process. Your estate is open to the public. So if you value your privacy to any degree, you want to try to minimize the probate estate that's involved. The next two bullet points kind of go hand in hand: living probate and conservatorship. That basically is the case where you becoming incapacitated or declared incompetent. And if in lieu of doing the proper planning for that potential event, the state and the courts will decide for you. And it's more of an issue for a single individual, but again, sometimes it's possible that people do become unable to take care of their own affairs simultaneously. So that's an important issue. And again, this gets back to people thinking that, well, I don't have to worry about that till I'm older. Well, if you ever have a chance, just Google Karen Quinlan is the name. She was a 21-year-old woman in New Jersey who basically got mixed up with alcohol and Valium and wound up in a coma for 15 years and had no estate documents like this. And it was a legal battle between her parents and the state and the medical profession for over 15 years, and enormous sums of money spent in legal fees. And again, with proper planning, this situation could have been mitigated. So again, even if you're in your 20s, planning for your incapacitation makes sense. We talk about having no will or relying totally on a will. We're again hoping that no one in our listening group or our client base will have no planning whatsoever. Relying totally on a will has some shortcomings. We'll talk about that a little later. And there are many low-cost ways and some ways that do cost significant sums to avoid having to rely totally on a will. So we try to use all the tools that are available to us. Likewise, relying on a joint tenancy arrangement. Typically, it's husband and wife, although it doesn't have to be. That can be an estate planning tool, but it may have some shortcomings that you need to possibly be aware of. And then lastly, as I mentioned earlier, for young families, not appointing a guardian for minor or disabled children can certainly be an issue. And again, we don't want the state to decide that for us. So when it comes to transferring assets, state assets at death, it's going to take place in one of two ways. Through a term that's called a will substitute, or through the process of probate. So let's talk first about will substitutes, because if we can utilize will substitutes, it's generally a much lower cost and more efficient way to transfer assets to our heirs. Okay, so just what is a will substitute? It might be a term maybe not everyone's familiar with. Basically, it's a form of death time property transfer that's meant to accomplish the same task as a will. So it basically functions the same way as a will, but it doesn't have to go through a probate process like the will. So the administrative element of it is much, much less. In many cases, the cost is non-existent or relatively small. So it accomplishes the same thing as a will, but it does it more cost effectively and more simply from an administrative standpoint. So here's a list of some examples of will substitutes. The death benefit of a life insurance policy. You are basically going to always have a named beneficiary on a life insurance policy, and it can sometimes be a good plan to also have contingent beneficiaries if for some reason that person is no longer here. But basically, with a life insurance policy, the death certificate's presented to the life insurer, and the named beneficiary's identification is basically qualified, and the money is basically paid out. No court proceeding whatsoever. With IRAs, individual retirement accounts or arrangements, technically, traditional IRAs and Roth IRAs both pass through the named beneficiary. And I guess kind of a point we'd like to make, and one of our emphasis in this quarter, a lot of our clients will have a named beneficiary as their primary, but they don't take the time to add a contingent beneficiary. And again, a lot of people, husbands and wives travel together. Lo and behold, something bad happens to both of them. If there's no contingent beneficiary, basically the contract document itself governs how it's handled. And again, just like you probably don't want the laws of intestacy to determine how something passes, it's similar with the contracts. The IRAs have an adoption agreement, and I think Todd and I both were chuckling last week that we don't know a single person that's ever read an entire adoption agreement. So you want to avoid being determined.
Just explain what intestacy is real
Yeah,
quick.
yeah. Intestacy is the situation you die intestate when you don't have a will.
Right.
So that's what intestacy. I'm sorry I didn't define that earlier.
And I was just going to chime in real quickly. You talked about, this quarter being estate planning for us. Most people's estate plan is really going to start and end with the proper titling and designations on the account. So that's why we send out letters every year to make sure, A, any accounts that we're managing on your behalf are correct, and B, any other assets you have elsewhere or insurance policies have the right named beneficiary. A lot of headaches can be avoided, and you can avoid the probate and the courts altogether if your assets go directly to a beneficiary. So I just want to make sure that you understand that and the importance of it. We joked that this slide, we could probably spend a good half an hour or more on it alone, but that's the tie-in. So if your TD Ameritrade accounts have the right beneficiaries, the whole thing with probate and needing a trust and things like that probably are necessary. So I just wanted to emphasize that point.
Right. Yeah, and then again, one of the reasons we try to do it on a regular basis is as things change in life, people get married, people get divorced, people pass away, and you want to make sure that everything is up to date when it comes to named beneficiaries. Employer-sponsored plans, 401ks, 403bs, 457s, similarly have a named beneficiary. And again, we recommend you have a contingent beneficiary. Otherwise, the plan document will determine the disposition. So you want to make sure it happens the way you want it to happen.
I'm sorry to interrupt you. One caveat with that, a lot of folks have some legacy plans kind of lingering. Generally, people switch jobs, they move on, and they have an old 401k, 403, 457. So it doesn't get as much attention. So pay close attention to those. There's been many cases out there where somebody was divorced and their previous spouse was actually the primary beneficiary of their old 401k because they forgot about it. So think of this as a trigger, and our letters every year is a trigger to think of all accounts, not just the ones that we may see here. So
right, yeah, and again, a lot of states are basically have laws where to try to prevent that divorce inheritor from happening, but not all of them do. So you don't want to leave it up to chance. That's really the most important thing. All right, joint tenancies. Basically, joint tenancies mean there's more than one person owning the account. And JTWROS, some of you may be familiar with, that's joint tenants with right of survivorship. That's going to avoid probate because let's say you have two people that own the account, each own the account entirely. The first person passes, the second person inherits it by survivorship. And so that's a way to economically pass the assets to the inheritor. A lot of people who promote trusts will say, well, all a joint tenancy does is postpone the probate because after the second person, the property becomes wholly owned by the second person. That person has to make some stipulations. If they don't, then that asset will wind up in probate. So that's one potential drawback if the second person own it doesn't act on it. There also are some legal potentially situations with joint tenancies. Tenancy by the entirety is not allowed in every state. Colorado does not allow it. We have some clients from Florida. Florida does allow it. Both types of accounts, though, do pass through survivorship. Tenants by entirety has a little bit stronger legal protection. So if with the joint tenants with right of survivorship account, if party A of the account is sued, party B could lose their element, their ownership of that if there's a judgment, whereas that cannot happen with tenants by the entirety. So we have a client who's a physician down in, who happens to live in Florida, and he and his wife own their joint account by entirety because that protects the amount, because even a malpractice suit against this particular physician would not jeopardize the account that's held by the entirety. Now, some of you may also be familiar with a term called tenants in common. Tenants in common is not a will substitute. Tenants in common are oftentimes uneven percentages. You might have, say, three family members who each own 1/3 of an account. Well, if party A passes away, party B and C do not become the owners by survivorship. The party A's interest goes through their estate and through the will. So tenants in common is not a way to avoid the probate process.
I was just going to say real quick that it's a pretty complex area. We could spend a lot of time on that. I think there are tax ramifications and situations Frank's talking about. So check with your accountant or attorney before you title a particular account, and we'll guide you on that if it's here. But I see it pretty commonly, like a mother or father will just decide to put their child on their bank account. And that's not necessarily the best way to do it. So you got to be careful.
Yeah, Todd's a good shill here, leading in for me here. The POD is a payable on death designation for bank accounts. Transfer on death is a similar thing for securities accounts. Oftentimes, maybe an elderly person might decide to put their child on the account as a joint tenant. Well, what you have basically done is made a gift to that person, and that can have some tax ramifications and whatnot. Probably a preferable way to do that, if you wanted to have your adult child maybe writing and paying bills and writing checks for you, you can get a convenience account at the bank. And then the POD and TOD basically are what happens when you pass away. So, depending on what your objective is with that account, you might consider a convenience account, you might consider it a payable death or TOD. And like I say, before you do a joint tenancy, you want to make sure you understand the ramifications. Real estate is kind of an interesting thing when it comes to the estate planning process. Normally, your financial assets, your personal assets, they are probated in the where you live. Your domicile, as a legal term is. Your domicile is where you basically call home. It's where you register to vote. It's where you register your car, things like that. You can live in multiple states, but you only have one domicile. Real estate is probated in the county where it sits. And we'll talk a little bit later about using trusts for certain purposes. But if you happen to own multiple properties, you want to consider maybe some estate planning in that regard to avoid what's known as ancillary probate, because you could wind up with probates going on in multiple states. So you have to be careful with that. But beneficiary deeds are permitted in some states. Basically, for real estate, an individual can name an inheritor, and there has to be a beneficiary deed filed in the courthouse. There's a cost to file the deed, but basically the courthouse knows that once you've passed away, the title transfers without going through probate to the beneficiary stated on the beneficiary deed. Colorado does allow beneficiary deeds. I think I checked on Florida. I don't believe they do. There's about 20 states that do. So it's depending on the state. Lastly, trusts are a way to avoid probate or minimize probate. And the way trusts work is that the trust actually owns property. And when the original person, usually the trust you typically see with estate planning, the original creator of the trust, known as the grantor or the trustor, is the initial trustee. And basically, when that person passes away, there's no change of ownership. The trust owned the property when the first trustee was alive. The trust continues to own the property when the second person takes over. So really, there's a change of trustee, and you name a successor trustee in the trust document, but there's no need for probate because the property never really changed hands. Okay, let's talk next about the process of probate. And basically, it's a court process. And probate it has hundreds of years of case law and legal history because it dates back into Old English law. It's a process of validating the will and passing ownership of your property to heirs, and it clears title. It protects multiple parties. The executor, as long as they follow the probate process, they will be relieved from any responsibility once they distribute assets to the heirs. So there's notification processes and lengths of time before assets can be distributed. As long as the executor follows that process, they're protected. And if they were to give property to one of the heirs and a creditor raises their hand later and says, wait a minute, you can't give the title to that because the deceased person owed me money. As long as that the process has been followed, that creditor has no standing. Heirs are protected because they get clear title to things, and creditors get the opportunity to raise their hand and say, hey, I have a debt that's owed to me by the deceased. And again, the term probate comes from probare, it's Latin, to prove this was what the deceased wanted to do and to prove all debts and responsibilities. And again, you will go through probate if you have a will, but there's, like I say, various states, the probate process can be more or less onerous. How much does it cost? I just ran a Google search yesterday and just tried to find some numbers. I found a law office in Fort Collins, Colorado, and he really stressed that if you did it right, it wasn't very expensive. LegalZoom said about 10% of the probate estate. Another law firm said between $3,500 and $5,000. Number 4 is the one I probably would answer myself, is you really can't tell for sure. Do you know how complicated the estate is? But the one thing that you read from every estate planning attorney is that they all agree that a lack of planning and unnecessary complexity are what drives up the costs. So you want to try to avoid that. We looked at Colorado because the majority of our clients are here, and there's really 3 levels of probate in Colorado. In a very simple estate, if the person has no real estate and they have personal assets of under $64,000, the devisees and the heirs are basically the kind of same thing. What's a technical term? But basically, the devisees and the heirs who are in the will can prepare an affidavit for collection of personal property. It's filed with the court, and there's really they don't even open a probate proceeding. So that's in the case of a relatively simple estate with no real estate. In the second case, it's called an informal probate. If you have a clear will, a clearly defined will that's judged valid, there's nobody contesting the will, and the named executor in the will is ready to serve and willing to serve, an informal probate can be petitioned, and the court will have some oversight, but basically you don't have all the hearings, you don't have all the legal entanglements. The court kind of supervises it. You still have to follow the notification to creditors and that sort of thing of the passing of the deceased person. But it's a simpler and relatively less expensive. And from what I can understand, it's fairly common in the state of Colorado. And again, the worst case is the third choice. The cost can be almost unlimited. And again, if there's no will, again, now you have an intestacy situation. So you know the court's going to be involved there. If there's a contested will from some of the heirs, and wills are easier to contest than other planning tools. So that if you've got potential heirs that perhaps may not get along or could contest how they're being treated, that can drag things out and create a lot of cost. I mentioned Prince, his will was contested, and that is dragged out thing. Michael Jackson, same way. So famous people, their wills tend to be contested. Complex estate could be multiple properties, could be a lot of individual accounts that don't have TODs or other ways to pass them. So again, you want to try to avoid option 3 there.
I was going to say, we keep talking about, or Frank keeps mentioning celebrities. I think sometimes it's hard to relate because we think, well, we're not going to have the estate that Michael Jackson had, or it really doesn't apply to us. But we see this every day. I mean, I had a client that his probatable estate took over 6 years to finally settle. And that just happened a year ago. So it can happen to anybody. So that's part of why we're talking about this. And I think you mentioned, I just wanted to clarify, Colorado is a pretty easy probate state. Other states are not so kind and friendly. But for the most part, probate in Colorado isn't something you want to try to avoid at all costs, like some attorneys may tell you. So just keep that in mind. Every state's going to be different. If you have property in multiple states, Frank mentioned that could complicate it. But if everything is in Colorado and you have everything titled properly, probate really shouldn't be a huge issue. So.
Okay, again, kind of just to summarize some of the advantages, it can take time. 12 to 8 months is an average here they're stating, but of course you've got these 6 and 7 year estate cases that pull that average up. What I read from several attorneys, they feel about a year is what is a good expectation. Still a long time, much longer than it would with will substitutes, but not 6 to 7 years. The amount again varies on the complexity. A big issue again is privacy, because again anyone can find out about your affairs in a probate file. And again, I mentioned that there's hundreds of years of legal history. Again, probate it's much easier to contest the will, so they're trying to protect all the interested parties, and so the court goes out of its way, I think, to hear the objections of potential heirs. Down at the bottom, it talks about a living trust. We're not here to sell living trusts, but living trusts have a lot of advantages, and we'll talk about them here shortly.
Yeah, I was just going to compare probate versus a will substitute. So we're talking about beneficiary designation. So people don't even think about this, but if a beneficiary shows up at our office and says that the account owner has passed, really they just have to indicate and show that they're the beneficiary, show a death certificate, and we essentially transfer the assets. That's quite different than something that doesn't have the right beneficiary designation or no designation, then it has to go through this probate process. So I have people ask me that frequently, what happens for a beneficiary. It's a really seamless, pretty easy process as compared to no beneficiary.
Yeah, our custodian actually performs it, but we facilitate it. Okay, I think it would behoove us to spend a few minutes talking about a trust. People hear that term all the time, and many people don't really understand what a trust is unless you're an attorney, or a financial planner. But basically, a trust is a legal entity. It's really similar to a partnership or a corporation. It's a legal entity that's separate and distinct from the individual that created it. The terms are typically grantor or trustor. Basically, someone wants to utilize the features and advantages of a trust. A legal document is drafted, and the trustor transfers the property into the trust. So the ownership changes. Trusts are controlled by the trustee, who may or may not be the original grantor. The trust can be revocable or irrevocable. When I mentioned living trusts that are typically used for estate planning typically are revocable, so you can basically change those. Irrevocable trusts, and this gets into gifting rules again, irrevocable trusts cannot be changed. And so when someone places property into an irrevocable trust, they are giving it away permanently to the trust and the beneficiaries of the trust. Just like an individual, a trust can own property. And I'll point out a real good example of my own case. I happen to own a house in Wisconsin, and I live in Colorado. If I were to pass, my wife and I own our houses as joint tenants. If I pass away tomorrow, she becomes the owner, and anything that would take place in El Paso County, Colorado. However, because the property is in Wisconsin, because a real estate has to be probated in the place where it sits, it would be in Barron County, Wisconsin. Well, I've created a trust, and I don't own the cabin in Wisconsin. My trust owns the cabin in Wisconsin. I'm the trustee of it, and I can act on it. I can sell it. I can do whatever a regular owner would do. But technically, I'm not the owner. The trust is. And I've got a good friend who's my successor trustee, who happened to be a real estate agent. So and a bank, a mortgage banker. So when the time comes to, if I were to pass, he becomes a successor trustee. He can handle everything, and my wife just basically has to sit back and deal with everything else. Trusts are really good at a standpoint of creating a great degree of flexibility. When one of the earlier slides talked about controlling your assets, you can put stipulations in trusts to do all sorts of things. For instance, if you have an heir that you would like to inherit property from, financial assets perhaps, but you're concerned that they may be too young or too immature to be able to handle it, you can put stipulations that the trustee is to distribute it at the age attaining the age of 35. You could, if you have maybe potential heirs that have substance abuse or alcohol abuse problems. You can put stipulations in there stipulating that the trustee is not to distribute it unless they can justify and prove that they've not had the problems or they've solved their substance problems. Likewise, you can have incentives. Property is distributed when the person attains a college degree. So there's a tremendous amount of flexibility with trusts, and that's, you know, the old saying is you can control your assets from your grave, in a sense, by using a trust. There's other things you can do with those. You can, you know, I mentioned that wills are a lot easier to contest. You can put a no contest clause in a trust, which basically says that if one of the beneficiaries contests the will or the trust document, they lose their inheritance. So that usually stops that right away. So again, as I mentioned earlier, with the fact that there is no probate because there's no ownership change, you name a successor trustee, and when the original creator passes away, the successor trustee steps into their shoes and handles it from that point on. So far, so we talked about a lot of the advantages of trusts. The last one is the disadvantage. It does add a considerable, can be considerable, but not always, degree of cost, and some complexity. The states have done a lot to try to minimize the unnecessary costs. You might be familiar with Uniform Trust, the Uniform Gift to Minor Acts. Those are basically prepackaged trusts for minors to have property because a minor cannot own it, and the custodian basically takes care of it. So that's a form of a more simplified form of trust. But when it comes to estate planning, the trust can get rather elaborate. A good living trust does avoid probate, again, because the property never changes hands. It does protect your privacy. It is revocable in most of the living trusts that we deal with for estate planning. There are some irrevocable ones, typically with life insurance for people who are very, very wealthy. There are protections in terms of lawsuits. As I mentioned earlier, joint tenants or right of survivorship, if one party gets sued, the other one could wind up losing assets as well. Whereas with the trust, they can sue the individual, but the trust is the one that owns the property, and so it does give you some protection in that regard. And because of the potential for non-contestability clauses in a trust, they're much more difficult to challenge than a will. So here's a kind of a quick schematic that points out some of the advantages versus disadvantages. With a will, you've got some time involved. You've got the courts involved, depending on how complex the estate is and the state you live in. It's public disclosure and can create some negative family impacts. If you don't have the proper documents executed, there could be court guardians and conservators appointed and potentially fees, and they could be contested. Versus the trust, which again, they don't mention the cost here as a disadvantage, but there is no court control, there's no probate involvement, it moves relatively quickly, and as long as the successor trustee is willing and capable, that they follow the rules of the trust and have a fiduciary responsibility to do that, things go pretty smoothly. So again, trusts have the advantages, but the downside again is the complexity and cost. All right, we could, Todd, I commented on this, we could have a whole presentation on this one slide if we wanted to. It would at least fill up an hour. I'm just going to hit some high points.
Don't give tax advice.
And, yeah, some things to think about. Capital gains tax can come into play with estates and gifting. When you think about passing something to the next generation, you can give it to them while you're alive, or you can pass it to them through after your death through probate or through will substitutes. With capital gains, if you were to have purchased an asset, say for $10,000, and now it's worth $50,000, if you gave that asset to a child or grandchild, a son or somebody else, they would get your same cost basis and your same holding period. So you would pass the tax liability on to that person, and there would be no way to avoid it. If they inherited, however, under current law, the basis would step up to the date of death value. So that the difference between $10,000 and $50,000 would disappear because they could sell it the day after you passed, and their cost basis would be the $50,000, which was the date of death value. President Biden has talked about lots of things, his proposals for increasing the federal revenues. He's talked about doing away with the stepped up basis. We'll see what happens there. We really don't know. A federal estate tax, as Todd mentioned earlier, right now only about 1% of states have an issue with that. Right now, the what's called unified credit allows 11,800,000 to pass without any involvement with a state tax. Two spouses, could double that basically, and even the second spouse can now use the unused portion of the first spouse's unified credit. However, the current setup at 11.8 went into effect in 2017, and if there's no legislative changes whatsoever, that will expire in 2025, and it's going to revert back to 5 million. So there's changes in the middle if nothing is done legislatively. There's also been talk about changing legislative changes with the state taxes. The state tax is political football, and so it's always being battered around in Washington. So it's the kind of thing you want to pay attention to because at some point it may affect the states that are much less. So that's a state tax and a gift tax are kind of connected together. We'll talk about that in a second. But that's a tax on transferring the assets to the next generation. Inheritance tax is the tax that's assessed by some states. Colorado does not have one, but many states do. New Jersey, Illinois, Maryland, Connecticut. Some states have fairly steep ones. That's assessed on the inheritors, and that basically taxes their right to inherit property. So again, planning for that can have some beneficial tax savings. Gift tax, again, the term is called unified. It's unified with the estate tax. And the reason they've done this is that think about a wealthy person on their deathbed. The thinking was, gee, we'll just give everything away 3 days before we die. And all of a sudden the estate tax is going away because I died with no assets. Well, government's a little smarter than that. And so what they've created is a set of rules for giving things away, time periods. In some cases, there's look back periods when you give something away. But in terms of the gifting rules, any individual is allowed to gift $15,000 to any other individual, any number of individuals. So one person could give $15,000 every year with no estate tax or gift tax ramifications to an unlimited number of people. If they're married, they could consent to what's known as gift splitting, and then you could give $30,000 away. However, if you exceed those limits, that's where gift tax comes into play. And they typically wouldn't you'd have to file a gift tax return. It may not cost you any money at that time, but basically what that does is it uses up some of that unified credit that applies on the estate tax when you eventually pass away. So they're kind of linked together. If someone's interested in gifting, you might call us and we can explain the rules on that because they can get a little complicated. The last one, IRD, income in respect of a decedent. What that basically is that saying decedent. If the person passes away, say you were a owner of a business, a sole proprietor, and you had accounts receivable, that is income that the decedent had the privilege of receiving. So that's going to be taxed as income in respect of a decedent. Same thing with commissions if you're a salesperson. Where it comes into play mostly for us is with IRAs. That was, since most IRAs are pre-tax and the earnings have never been taxed, as we're pulling the money out of the IRAs ourselves, the government is recovering some of the taxes on that amount because that was income that we postponed, if you will, during our lifetime. When unlike an asset that's owned in a taxable account, when you pass an IRA to the beneficiary, the taxes do not go away like they do with the capital gains under current law. So that can become an issue, and especially now since the Secure Act of 2017 changed the treatment of RMDs, if you will, or actually did away with RMDs for a non-spousal beneficiary. That's a whole nother topic for their situation. But if you're concerned, if you have a relatively healthy IRA and you're concerned about a non-spousal beneficiary, maybe a contingent beneficiary, or if you're not married, passing it to a child or some other individual, there could be a big tax bill passed along with it because the rules have changed to where they now have to consume that account in 10 years. So that's something that you might want to discuss with us and with the CPA.
Yeah, this is pretty technical. He said RMD, which is required minimum distributions. If you're not aware of that, when you're 72, in the year that you attain the age 72, you have to start taking money of your IRA, your individual retirement account, but also if somebody inherits your individual retirement account, they also have to take required minimum distribution. So just want to clarify for those who don't know what an RMD is.
Okay, let's talk quickly. We'll move away from the financial topics and we'll talk about the situation of not being mentally competent. Okay, living probate occurs when you become incapacitated. You can't make decisions for yourself. Once you've been declared incompetent by a court, anyone can be appointed. And that's something that I think all of us would want to avoid happening. I know it's challenging and difficult to think about becoming incompetent yourself, but it does happen. And I think we all would want to control who the person who can take care of our property and our health at that point is. So that's where the right documents can make a big difference. All right, so how do you guard against a living probate? First you have to make a conscious decision. Let's take care of this and get the necessary forms executed while you are competent and establish the powers of attorney and a conservator. And again, the key is that you are able to decide while you are competent as opposed to it's too late when you're incompetent. All right, so the necessary documents, there's two powers of attorney. One is a financial power of attorney, one's a medical power of attorney. And a third one is a living will, also known as an advanced medical directive. A couple of key terms. With a power of attorney, with a power of attorney, basically you're naming someone to become your agent in fact. And if you've ever been had to sell real estate and maybe you've been transferred for a job to another state and you had to move to the job and you sold your property at your previous state that you lived in, and you couldn't, rather than having to come back to the closing that was going to take place 3 or 4 weeks later, or whatever, you may have named a real estate agent with a power of attorney. It was a very limited power of attorney. It would only allow them to do one thing, which is basically represent you at the closing and sign the papers for you. So powers of attorney are very common, but in many cases, you're designating someone else to act for you. When it comes to this type of thing with estate planning, it's very important that the power of attorney be classified as a durable power of attorney. And the estate planning attorney should know all this, but it never hurts to remind them. There needs to be language in the document that names your power of attorney. That when you become incompetent, it basically the language says this power of attorney will remain in effect once I'm declared incompetent, or something to that effect. Because with a traditional or typical power of attorney, it would no longer be effective when you became incompetent. So the term durable guarantees that when it's needed, it'll be effective. The person or persons you designate could be the same person. It could be two different people. You may have a situation where maybe a family member understands, and you communicate to your family member what your wishes are for medical treatment if you're unable to decide. But that person may have no clue about finances, so you may assign someone else to be your financial power of attorney. Again, it could be the same person, it could be two different people. It's worth thinking about the characteristics of the people you're selecting, but more importantly than anything else, this has to be done while you're competent, because once you're at the point where you're no longer mentally competent, it's too late.
Yeah, quick comment there. We've had situations where we've had power of attorneys on the account with TD Ameritrade, and they thought that they had the ability to act on the account, but they were not durable power of attorneys. Therefore, if that particular client was incapacitated, even dies, that power of attorney goes away. So I've had situations where we've had to tell power of attorneys that we wouldn't be able to help them under those circumstances. So that's a good point.
Yeah, I mentioned the living will. Another term is an advanced medical directive. Basically, with that, you're expressing your preferences on life-sustaining procedures. So artificial nutrition, hydration, you're in a coma, they keep you alive with machinery and with artificial, food and hydration, various treatments and whatnot. You can express your wishes in the medical directive that you do or do not want to be, and you can specify periods of time. You can also donate organs and tissues with that document. We do want to point out, though, is some states have, physician-assisted, death with, they call it death with dignity statutes. That is a totally different document. So if you're predisposed to want to have a physician, when you're terminally ill and to assist with medication to cause your life to end, that needs to be executed separately. So don't believe that the medical directive governs that. There's a separate document that lists your preferences in that regard.
And Fred, I think he left, but he also is a medical professional that had some experience in this area. He suggested a book, a really good book, as well as a couple of websites I'll send out to everybody as a resource in that particular area.
Okay, so kind of to summarize, when it comes to passing things to your loved ones, you can do it several ways. We're hoping that none of our clients fall into group number one. That basically is relying on the state law, and it may not be what you want it to be, and it's going to be more expensive and more of a headache for your heirs. You can do it yourself. I mean, there's websites, nolo.com, LegalZoom. One of the challenges with that is you got to realize they don't know what state you're in, and they may be able to customize it to some degree with certain states, but as we've seen, property law and probate and estate law can get kind of complicated. You can be inadvertently doing some things that may have some negative ramifications. So while I say this may be a cost-effective way to do it, you're assuming some risks in that regard, unless you're an attorney yourself. You can work with an attorney, which again will give you the greatest degree of customization. Unfortunately, the costs are going to go along with it, but that person is professionally liable to basically follow your recommendations and desires. And then as an alternative, maybe between number 2 and number 3, level 5 has acquired a service that basically we're not the attorneys, we're not drafting documents. We can act as the facilitator and collector of information, and these documents are prepared by attorneys and reviewed by attorneys, just incorporating information that we would provide to them. So this could be an alternative. As Todd mentioned earlier, many people may already have had their state documents done, but their children haven't. This could be a relatively low cost and easy way to take care of that.
Yeah, and like what I've told people, we're agnostic to really 2, 3, and 4. We may talk you out of 2, but for the most part, we just want to make sure people have it taken care of. And if you remember one of the beginning slides, anywhere between 65 and 75% of households haven't done this. So if we can help remove the barriers, whether it's procrastination, cost, or ease of doing it, that's why we're having this presentation and offering kind of an in-between service to help you get it done. I think a lot of times having a relationship with an attorney is good, and it's important. You have that ongoing relationship. Other times the complexity, your estate complexity may dictate that you don't need an attorney, and the extra costs associated may not be worth it. So we can help you make that decision as well.
Yeah, just to kind of chime in what Todd just said in terms of complexity. I mean, my personal experience, my mother-in-law, she didn't own a house. She was living with one of her daughters and had a relatively small estate. We had taken care of her accounts, making sure that they were beneficiary specifications and TODs, transfer on death. So basically, her probate estate would have only been her clothes and her personal belongings. But somebody told her she needed a trust to avoid probate, and she spent thousands of dollars drafting it and whatnot. And if there was ever an overkill, I thought that was it. And that's what we're saying. If your situation was as simple as hers, which many of our clients may not be, but if it is, you may not need a trust. But the trusts are, as we said earlier, very, very useful and very valuable in the right circumstances.
Yep. So I guess that's it. The 4 Ps of estate planning.
Right. I think you can see these. We're trying to protect everyone involved. We're trying to minimize, we'll say, or avoid as much probate as we can. If privacy is important, that's another benefit. And then more than anything else, the peace of mind and the ease of execution. One of my stepdaughters just recently settled her dad's estate, and it was a mess for her because she didn't know where things were at. He lived in Illinois, she lived in Colorado. Traveling back and forth was a real headache. Working with the attorney, even though the attorney that drafted he did have a will, but he wasn't much help. So again, you can make things a lot easier. And this is kind of putting a plug in right now for the e-money vault. If you're familiar, if you've got an e-money
Personal financial website.
You got a personal financial website. You can scan and save documents on there. You give the password to your person that you're going to, basically take care of your affairs. It's great when they can find everything. Otherwise, they're searching for documents. They find things after the fact. It's a much easier way to keep everything in one place. So we'd encourage you to use it.
Yeah, so 2 ways that we're trying to help people. Everyone, every client should have received a beneficiary package in the mail. That is A, to make sure that your beneficiary designations on the accounts are correct. B, it was to add a trusted contact to all accounts. So that's a little bit different, that those particular designees do not have access to the account, but if there's a problem, we can contact them on your behalf if we can't reach you. And then thirdly, it was kind of a checklist of have you taken care of these estate planning documents. So if you haven't returned those, please do so. If you didn't receive them for whatever reason, give us a call. Tracy will get a new one out to you. But I can tell, we talk about procrastination. I can't tell you how many packages we've sent out versus how many we've gotten back. And I see somebody smiling. His first name starts with a G. I won't say who you are. So it's our, as your advocate, we're just trying to facilitate this to avoid the procrastination. She's showing it. Yes.
It's a friendly nudge.
So, give us a call. This is a lot of information today. It can be a very complex thing, but I also don't want you to feel overwhelmed by it. And that's why we've offered kind of that in-between service where we can make it painless. So if it's daunting to you, if you think it's too time consuming, we can help facilitate. But if we think you really need an attorney, we're going to send you in that direction as well. So we're almost at the hour. I want to open up for questions if anybody has any. Go ahead and put it in the chat box or go ahead and unmute yourself. And if you don't have any questions, I'm going to start calling on you. Ginny? No, I'm just
So I have a question. Can you give me some examples of digital assets?
Sure. Are you on Facebook?
Yeah.
That would be a digital asset. Do you download music anywhere?
No.
Okay, you have no digital assets. And anything you do online would be a digital asset, essentially.
Yeah, if someone has a business, has a website, that's an asset, digital asset.
Okay.
So people don't even think that for those that are maybe a little bit more active on social media or do a lot of online stuff, just passwords. That can be a nightmare for surviving spouse or family member. So anything that you think you do in the virtual world, you'd want to at least have a list. So we talked about the personal financial website. I provide that free of charge to all clients. In the vault, you can store passwords and things like that. You've heard me probably talk about this before. Frank coined it the doomsday book that he gives his wife. Well, the personal financial website that we provide is similar, except it's online and it's secure. So we encourage people to anything that you would think that your family member would need access to, you could put in there.
Yep.
So that would be a digital asset. But for a lot of people, it's music, social media. If you have a business, it would be, like my websites that I have and things like that.
Yeah, my doomsday book, it's a how-to for my wife. Here's where you're going to find everything. Here's what you got to do. So it's kind of a follow step-by-step process for her to, again, it's all about making it easier.
And I always say, if, your heirs don't know me, we should be in there. It's always better if you can make an introduction now, just so they know who they are or who I am and have a relationship, rather than waiting to that event and they're scrambling, who do I call, who do I contact, that sort of thing. So that's one way. So I offer that, if you want to introduce me to anybody, you're welcome to do so. Does that help, Ginny?
Yes, it does.
Okay,
Thank you.
sure. Anybody
So,
else have any other questions?
since you called out my name, I'll give you a question. When you were talking about creation of trust and stuff, Fred came out and said that, it had spent thousands of dollars on a trust and stuff, but just for kind of a ballpark, if you're looking at, maybe household items, single piece of real estate, car, that type of stuff to set up the trust on that part, um, ballpark figure you'd be talking about? I mean, would it be thousands of dollars or a couple thousands of dollars or what?
So typically in any type of service that you're looking at two general packages. One is the will and the power of attorney type package. So it's a will package, it does not include a trust. And then the other one includes the same, but also the trust. So it really depends. So for a basic package, on average for attorneys, I've seen, under $1,000 at the low end, upwards of 1,500. And once you throw the trust on, I've seen anything from kind of 1,500 all the way up to 3,000 or 4,000. It just depends on the state and that attorney. The in-between service that we were talking about, that we're saying that might help people, those two packages instead are usually around 400 for the first package and around 700 or 800 for the second package. So those are the general ranges that I've seen.
Yeah, sometimes there's some costs above and beyond the trust. For instance, if you're transferring real estate into the trust, you're having a deed recorded. There's it's not the attorney's cost, it's the courthouse charges you for that, recording process. So sometimes there's some costs that are, you just can't avoid them.
That's a good point. Yeah, that client, I was talking about the different options, and for this particular client, I was saying, an attorney might be better for you. However, if we were to shepherd you through this more streamlined process, if you will, this is what it would look like, and this is what the cost would be. And I told him that particular platform, it's $250 for a deed. And he said, well, I have 24 different deeds, so that would be $6,000.
Mhm.
And I had to explain to him that whether he does it through an attorney or does it anywhere else, that's going to cost the same essentially. Our partnership offered to cut it in half for them, so it was going to be 3,000, but still that's a significant cost. But yeah, that's a good point. That doesn't really change because that's with, your municipality. So,
Right,
does
right.
that help? That help,
Yeah,
Jamie?
I mean, it talks me off the ledge of thinking, $10 to $20,000 to thinking, three or less. I mean, that says, okay, we can continue to talk. But if we were talking, 10 to 20, it was like, procrastination right there real high.
And without giving too much information, but knowing your situation, I could see you, on the lower end of what I offered. So
Yeah,
I think if you found somebody in Florida, if you wanted the trust package, so to speak, you're probably looking at 2,000-3,000 maybe. But
yeah. Okay, thank you.
sure. Anybody else have any questions? Okay. Well, this is going to be recorded. I will send out a recording to everybody. It will be on our YouTube channel as well. That would be a digital asset of mine, Ginny. It's a good example. I just thought of it. So that'll be coming out probably tomorrow or the next day. Look for future events. So if you don't go to our website very often at level5financial.com, we do have an events page. So you'll see more and more happening there. So we're already getting to April. We'll be having our monthly coffee chat coming up, as well as our happy hour. That's on Tuesdays and Thursdays, respectively. Looking at my wall calendar here, I believe that will probably be the 6th and 8th of April. But look for email invites on that. We're also, as I mentioned, getting into the next quarter, so we're switching themes. So for those of you who have been to many of these events, you're probably over the estate planning theme, understandably. We're moving into kind of the tax planning theme. So we know that tax preparation deadline has been extended a month this year. So you're still probably, some of you still working through that, but we're encouraging everybody again to get your tax returns to us. We were going to be a second set of eyes on everybody's tax return. That's part of our review process that we do every year. And then we'll probably have another webinar in this format, either in April or May, on tax planning as a general topic. So one more call for questions before we close down. Just want to double check. Laird, go ahead.
Yeah, you just talked about the extension for the taxes. Does that include everybody? I mean, if we've already turned our stuff over to our, our accountants, do they then wait for the next thing? I saw an email about it, and to be honest, I didn't understand everything they were talking about.
So, yeah, good question. So typically it's April 15th. They extended it a month. So that simply just gives everybody more time to file everything. In terms of your accountant and tax preparer, it's really going to be their protocol. My understanding is most of them are not going to wait another month unless they have to extend people beyond that. So if they already have your stuff, they're probably going to get it as done on schedule. But they do have that added flexibility of having another month without having to formally extend somebody. Does that answer? Go ahead.
Yeah, okay. That was then, and that's the first part of it. Then the second part of it was they said there might have to be amendments because all of the rules and the regulations from the IRS haven't been totally, I guess, whatever, hammered into stone or whatever. So does that mean even if they filed, before, would we maybe have to do an amendment?
Yes. So remove the amendment option away from the deadline extension. They're kind of two different things. They may be somewhat related because or things could happen within that time frame. But generally what they're saying is ever since COVID, especially, they've launched new rules and new different loan programs and things. It's kind of been on the fly, and a lot of accounting firms were not made aware of this. So they've been playing catch up, for the last year. So they're just making you aware. I'd have to see the email, and maybe I've seen it if it came from yours. But they're just making you aware if something changes in the interim, even though they file you, there may be a reason to amend because of that. Just a caveat that everything is so fluid right now and in flux that, it's subject to change. So.
Okay. Yeah, and I kind of meant to follow up with them, but yeah, I will. So anyway, thank you.
You're welcome. Yeah, I would just give them a call. Like I said, a lot of them, I work with a lot of accounting firms, and, that they've thrown a lot at them that they've never had to deal with before or contend with. So literally people, accountants would be up at night like, oh, wow, they just launched these new rules. I have to learn this before tomorrow. And that's been typical all through, the pandemic. So good question. But every accounting firm's dealing with it differently. Some accounting firms will automatically extend people if it's too close to the deadline, because it's a volume game. They have 1,000 tax returns to do in a 6-week period, so they tend to extend and have cutoff dates. But if you already have your stuff in and they have another month, I can't imagine they're going to extend you unless there was some extenuating circumstance. So anyway. Any other questions? I see somebody has their microphone on, but maybe not. Okay. Well, like I said, the recording will go out. It'll be posted. If you have questions, certainly send us an email or give us a call. I thank you all for your time. Frank, good job. We
Thank you.
appreciate it. And yeah, we'll see you at coffee talk or happy hour next time. So be safe, everybody. Have a great night. Thank you.
Thank you.
Bye-bye.
Bye.
So how do you these things?